Welcome to It's a Mistake.
Good afternoon, good morning, good evening, good everywhere. Greetings and salutations. We are back again. Episode 8. What number, Frankie?
17.
17. And part two of our first one back. So a two-parter. It's nice to have everybody here. I hope everybody's listening. Don't forget to like, subscribe, and give us a 5-star rating and tell your friends that we're back. We're back again, and we're going to stay back for a while. And we have a couple different casts of characters now. We have Regan. Say hello.
Hello. Happy to be here.
Good. All right. Decide if you're going to stay. You're on probation. And then Frankie, Francesca, attorney. Hello. Say hello.
Hello, here for the 4th time now, technically.
Gonna keep track. What do you want me to give you?
I'm a regular now. I think I'm a regular.
Now you are a regular. You are definitely a regular, and it's good to have you. What do you have to offer today?
Today I have to offer that I don't know. I hope that everybody shoveled their mailboxes after last week's episode. And
Turn into last week's episode. You can hear about my U.S. Post Office rant. I don't think we need mail. I don't know why you want what we want. I mean, I think we could do without.
I like checking the mail. I like to see if I ever get anything exciting.
What do you think you're going to get?
Well, I'm at the age where a lot of my friends are getting married and having babies, so it's always like save the dates, wedding.
Well, let me ask you this: when your friends are getting married, because a lot of your friends are getting married, which is interesting because you're a divorce lawyer, are you receiving these invitations in the mail or by email?
Most of them are in the mail. I actually just got my first text message invitation, like a couple.
How'd that make you feel?
I don't know. I'm an old school kind of gal. I like paper.
Were you offended that it wasn't like a paper invitation?
No, it was cool. It was cool. I liked it. Everybody has like wedding websites nowadays anyway. So you basically get the invitation and you put it in your drawer and then you go online and check their wedding website out anyway. So I think it's both, but it's nice to get the piece of mail, I think.
Okay. Regan, what are your feelings about invitations?
Invitations, I think, is the one exception where I want paper. But other than that, no mail.
No mail. So you're anti-mail.
Email me.
Email you. So email Regan at reagan.com. I don't know. I don't know. If I can't get the mail delivered because of the snow, I'm going to just go with email. Screw it. And everybody's going away from it too. I don't want to go on another rant for 2 episodes in a row about mail, but the reality is like every day, from credit card companies, bank statements, brokerage, all these things, they're all saying, "Hey, go paperless. We want you to go paperless," because they don't want to spend the money on the postage, right? So it's faster, more convenient, and easier. I think it's kind of like change. Do you have any change on you? Anybody?
Never.
Never, right? Do you even pay in cash? Forget even change. Change
Never.
is like
I don't even have a credit card. Apple Pay everywhere.
Apple Pay, right? Everything's just going to be on your phone, right? That's how it's going. So I think
I've been checking the mail a lot recently because my driver's license expired and I needed a new one, and they only mail it to you. So that's one thing, and like your passport, your federal.
But
stuff.
you can renew it without doing that, right? You can go online.
Well, I renewed it online, and then they said it'll be mailed to you in 7 to 10 days.
Right. But see, again, like once you start introducing the doing everything online, it just kind of leads naturally to kind of like this paperless society. Like you don't have to have that mail. That could be like, UPS could do it. FedEx could send you the license.
I would have preferred to go pick it up day of so that I got it sooner rather than waiting.
You do that. You could do that too. You could definitely do that too. All right. Enough about the mail. I've ranted about that enough. We're going to talk part 2. I promised we would discuss a case that I think is important and overlooked by the bar because it was sort of came a little bit out of nowhere. Which brings me to my first point is we do a lot of appeals. You can get my book nationally on appeals. What's it called? The Family Law Guide to Appellate Practice is available on Amazon if you want. But one of the things I talk about in the book is, you know, you never know what's going to happen in an appeal. You never know what the jurists on the case are going to latch onto, and sometimes it can be surprising because sometimes they may look at an issue and you might see it one way, they might see it a different way, and so that I always caution people that when you appeal, you can make good law as well as you can make bad law. Not saying that that's what happened here, but I do think that in the case we're going to discuss, it is one of our own cases. The other thing is we do have a newsletter coming out. I don't know when this particular show will air, but that's something to sign up for our fans out there. Although Frankie, you're now on the show, you might have been our only fan, so you're already on. You made the show, so. But the case is called Ramanajam versus Kanadhan, and does it have it's published opinion, 2024. Does it have like a case site yet, Frank? Regan? Regan's my case site wonder person. Not sure it does. If it doesn't, you can find it at number 24-P-658. 2025, excuse me, the number's 24, but it's 2025. It came out, when did it come out? Do you guys remember? Came out
August 7th.
Last August. And I think people have kind of not paid attention. So, Regan, I'm going to have you jump in a little bit, but because I have your notes, you did a good job. Let's just talk a little bit about the facts. Do you have the summary in front of you, or do you need me to do it, Regan?
I can pull it up.
Oh, pull it up. Also talking. So the parties are married. So let me talk about a little bit of the facts, because the facts are kind of. So the parties were married for 16 years. They have 2 children together. They separated in July 2017 when the wife moved to a friend's house in the state of New York with the kids. The party had kids. The husband stayed in Massachusetts. So the husband files a complaint for divorce on March 16th, 2018, and he only seeks a divorce. The wife then filed an answer and counterclaim on March 27th, 2019, seeking a divorce, conveyance of the marital home, and equitable marital estate. Do I have that date right? Is it March 16th, 2019 when he filed, or 18? Regan, I have it. I might have written it wrong.
Originally, I think he filed 2018.
All right. So he filed well ahead, and then the wife files an answer a year later. Is that true? That's why I'm asking. I just don't know if I did a typo. Look it up while I'm talking. Anyway, the parties go to court in Massachusetts. Look that up because it becomes.
He tried to amend his complaint after that before she filed an answer.
Well, when did he originally file? He
originally filed in 2018.
Okay, and then did he ever amend it? It was never allowed, right?
I don't believe it was allowed.
Okay. All right. So we have a divorce complaint. Initially, 2018, they tried to amend, but he only sought divorce. He didn't seek anything with kids or anything else. Then the wife files an answer seeking a divorce, but also an equitable division of the state, of the marital estate. And then she claims that New York was the kids' home state at this point, and that Massachusetts lacked subject matter jurisdiction over custody, parenting time, child support. So the parties agree that Mass is not the home state of the children. New York is the home state. She files an amended counterclaim seeking child support in Massachusetts. She subsequently files a child support petition in New York. So her position, I'm just going to sum this up. Her position becomes that New York is the place for the children, for child custody and child support. The husband agrees that New York is the home state of the children and that custody is going to be in New York, but doesn't agree that Massachusetts does not have jurisdiction over child support. This becomes important. The wife, throughout the litigation, says Mass does not have child support. She seeks dismissal of the action related to child support. And the lower court never actually adjudicates that in the end. They say they will, but they never do. So, long story short, we appeal for the client. We did not represent him below.
The judge did, in her judgment, include child support. She just never addressed.
Right, but the wife had a motion to dismiss it again. The court said that they would look at it, and the lower court actually never made a ruling on her very last motion in time. What the court did was she did order 200 and whatever it was in child support. So we challenged the jurisdiction over the issue of child support. And so the issue was, what's the issue, Regan? I'll tell everybody the issue.
The first issue is whether Massachusetts had subject matter jurisdiction to issue a child support order.
Right, and of course, but that's under 2204, which is the Uniform Interstate Family Impact. And why did we say that we didn't believe that they did?
I do, yep, because we said that under Section 2-204 of UIFSA, when there are simultaneous proceedings, we said that the first filing for child support occurred in New York when the wife filed, and then request for child support here was filed. So jurisdiction should have been in New York, where the home state of the children are, and the child support petition here should have been dismissed so New York could adjudicate that.
And here's where it gets interesting. So we felt fairly strongly that under UIFSA, the personal jurisdiction is determined, and that because of the way the filings were made, that the wife, we were representing the husband, the wife was correct that Massachusetts should not have taken jurisdiction over the issue of child support. Makes sense. Home states in New York, the children are in New York. There were simultaneous pleadings. The statute seems to be clear that New York would be the appropriate form, and moreover, that the lower court never, although she issued a judgment that contained child support amount, never actually adjudicated the very claim that the wife had made that the court said that they would look at, which is whether or not Massachusetts in the end had personal jurisdiction. So what happens? What happens is the court found what, Regan? The appeals court.
The appeals court, first they found that the 2-204 section, which deals with simultaneous proceedings, that subsection B would apply here. Okay, because they said that the first filing involving child support in our case was the husband's complaint for divorce, because the complaint for divorce automatically invoked the jurisdiction of the Mass Probate Court to consider.
Stop right there. Now, what's important for everybody to understand is that the husband in that complaint did not seek child support and did not seek custody, and the wife sought to have that complaint thrown out for those issues because of the subsequent filing in the state of New York. But what ended up happening is the court, in its infinite wisdom, determined that because of the nature of the divorce complaint, as Regan points out, that alone allowed the court to take jurisdiction over the issue of child support. Do I have that right?
Yes.
Frankie's nodding her head, but people are listening, so we need to say something.
You do have that.
I have that right. So here's the lesson. This is to me, it's very interesting. So, and then I'll ask for a little feedback. But to me, my initial thoughts are from that case is that the facts truly matter, and they can often be extraordinarily determinative in family law appeals. So in other words, the practical realities do not stop at the appellate doorstep. The husband's early disagreement with the wife's argument regarding jurisdiction over child support worked against his argument upon his appeal, because despite what I feel is black letter law pertaining to the ability to challenge subject matter jurisdiction at any time, the fact that he didn't make that argument and agree with the wife to have the child support be determined in New York led to, I think, in some parts, the court taking a very broad view of a divorce complaint that makes the court have the ability to issue a judgment not only regarding the divorce but over personal jurisdiction. And my second point is, I think that for people's consideration, is that the appeals court also, rather to me strangely, left unresolved whether the statute is applicable to personal or subject matter jurisdiction. So in other words, the 204 statute, which I think is clearly talking about personal jurisdiction, because it talks about subject matter jurisdiction, subject matter jurisdiction over the custody, over support. I felt that was not anything that was ambiguous under the statute, but the court did. So that does leave it open to interpretation in the future as to whether or not it's talking about that portion of the statute is talking about personal or subject matter jurisdiction. I felt the subject matter jurisdiction. And then I think from a practical standpoint, practice pointer for everybody, is I think it's very important. And then I'm going to leave you off my final thought on this. A party, when challenging child support jurisdiction in the Commonwealth, should object timely in the Commonwealth, but simultaneously, if not prior to the service of the complaint, file their own complaint in the foreign jurisdiction so that there's competing complaints. They should not wait for the Commonwealth to resolve the issue of jurisdiction, because if you do, you can run into this sort of trap that happened here. But to me, the reason why this case is so important, and I think a little bit overlooked, although I know that one of the I think the Social Law Library was doing a review of the important cases, and they were starting with this case because they thought it was important, as I did, which is this, is because the court found by statute that the husband's complaint for divorce automatically invoked the jurisdiction of the Massachusetts Probate Court to consider an order of child support. That's key, because let's just take a quick look at what 20828 states. It says, upon a judgment for divorce, the court may make such judgments as it considers expedient relative to the care, custody, and maintenance. All right, so we have maintenance. So because it says maintenance under 20828, it invokes personal and subject matter jurisdiction, and you can have child support. So what does that mean in the future? Does that mean a party who has no contacts with Massachusetts can be forced to pay child support within the Commonwealth simply upon the filing of a divorce complaint? I think it does. And I think that's very important, because people move around a lot. And for the marital dissolution statute, somebody could file after living here for how long, Frankie?
1 year.
12 months, 1 year. So if they come here a year, but they have a kid, and the husband has never lived here, has no personal contacts, as we learned in law school, that person could file and get child support in the Commonwealth based on this case. Ramana v. what, Regan?
Kanadhan.
So that's why I think it's important. And secondly, and I'll leave you with this on this one, does this holding now extend to custody jurisdiction? It says care, custody, and maintenance. So does the mere filing of a divorce complaint trigger custodial jurisdiction without due regard for the home state of the child? Regan, what do you think? Yes or no?
No, I don't think so. I think there's
Okay,
still.
I didn't ask why. Frankie, what do you think?
I agree. No, I think
Why?
you can argue it, but I think ultimately it would be no.
Care, custody, and maintenance, 20828. Ramana. How's it no?
Can I say my why now?
Yeah, Regan, you go ahead.
Go ahead, Regan. Quickly.
I think this part of the statute is talking about subject matter jurisdiction, which is the type of case a court can hear, and then there still has to be personal jurisdiction, which would go to the home state of the child. I think you have to.
Yeah, that's true.
Do both.
Yeah, that's true. But what's interesting is the reason why I think it brings up some compelling issues and ability to argue off of this case is the fact that they didn't determine whether that part of UIFSA is personal or subject matter jurisdiction. So I think you make a good point that I kind of railroad through on the personal jurisdiction.
So that it was.
On the personal jurisdiction, to my point I was making before regarding personal jurisdiction, that is true. But they didn't determine that part of that statute. So does it really matter in the end? Anyway, fascinating case. And yeah, we're out of time. So look, like, Regan, subscribe. What do you call it? Comment, subscribe, post, whatever. It's great to be back, right, Frankie? And now that you're a fan, and look at you.
Number one fan becomes revolving guest on the podcast.
Very good. Well, we're gonna have more fun and frugality, whatever they call it. I'm gonna go shovel out my my mailbox and continue my war on mail. And hope everybody has a great day. And thanks for listening. And we'll see you soon next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.